As you all know, SCAI is a nodal body of shopping malls in India. We are making every endeavor to encourage the development of the shopping center industry in our country. Knowledge sharing with the industry professionals is one of the important responsibility of SCAI to apprise the industry professionals about the best practices happening in the other parts of the world. To fulfill this objective, we bring out a monthly magazine, Mall Talk, which talks about best practices and strategies being practiced in the industry. We have also started online masterclasses, which are conducted by the industry veterans, the professionals who have made their mark in the industry. The subjects of these masterclasses are such which may help the industry members in enhancing their knowledge and day-to-day operational skills. 5 online workshops have been conducted. Today is 6th in the series, and the subject is Agreement with Licensees, Your Rights and Duties as a Licensor. Mr. Mukesh Kumar, he is CEO and Managing Director of Quest Properties India Limited, a well-known name in the industry, an industry veteran whose expertise on the subject is acknowledged by the professional fraternity. He is conducting today's masterclass. Viewers can post their questions, which he shall be answering in the question and answer session. So let's welcome Mukesh. Mukesh, SCAI, and all the viewers welcome you. Over to you.
Thank you, Anju. Thank you very much for the introduction. Let me first clarify, I'm not a veteran in this field, just 10 years in the industry. If you're looking at the retail industry is concerned, started my career in 2011 in the retail field. So I would say around 12 years. Thank you very much. And Sunil and Anju, you guys are doing a great job in organizing this masterclass because it's very, very important for the industry to understand and take something from the people who work in the industry for a very, very long time. And I'm happy to share the knowledge what I have so far. Definitely, I'm not a lawyer, but I do know about the commercial aspects of all the agreements because I've been dealing with this for past 10, 12 years now. And I do understand that sometimes the people in the leasing field, they find it very difficult to talk to retailers when you're doing an agreement in terms of legal clauses or commercial both. So feel free in case you have any questions on this. Maybe after the session, it's going to be 1.5 hours my presentation, which will cover the basic points about the basic commercial. Then you talk about your licensees obligations, licensors obligation, what is their right, what is the duty, what is expected out of them, what is expected out of us. We're going to deal with all these subjects and take the basic understanding of all the legal clauses in the agreement. End of the day is about how to protect your right, at the same time make sure the licensee does their business that they want to do, they conduct their business, and they have to make their revenue, and only when they make their revenue, you make your own revenue. You also must understand that when you're doing an agreement that you need them as much as they need you. It's both ways. Sometimes we fail to realize this fact that it's two-way process. It's not just one way. Sometimes we go overboard in accommodating some of the commercial and the clauses both so that you don't lose them. That's not very important. You need to understand as a licensee you have certain rights, and very important to make sure that the commercial that is good for you is making sense to you should only have as part of the agreement. Not because the licensee wants something and they're pushing you for it. But at the same time, when you're dealing with an agreement, you need to understand why something is written there, what is the purpose of this, and how do you defend it. What do you say it and why do you say it is very, very important for you to understand. So these are basic aspects of any agreement. And if you can defend all your legal clauses and your commercials, I don't think it's going to be an issue in signing any agreement. Yes, I do understand some of the larger companies, they're a little more pushy. Sometimes you find it very difficult to deal with them. So the international brand, they're very pushy. And repeat, in my career also, I've noticed some agreements taken us more than a year to sign those agreements. But that's the name of the game. It's a game of nerves. You need to keep your nerves when you're doing an agreement, whether it's a commercial or the legal both. As I said, it's their requirement as well. So you need to protect your rights. Having said that, let's go to the basic thing. What exactly, when you do an agreement, what's the objective of mall owner? Enhance his revenue by enhancing retailers' revenue. In the ever-changing environment, target group changes and their preferences also changes as well. Therefore, the brand mix need to be changed. You can only do this in case you have the flexibility to change the brands more often. That means it's very important to understand that tenure can't be unlimited. That means retailers cannot be given permanent right to continue operations in the licensed premises. In the Indian context, rights can be contractually given broadly under three following terms: Lease in the Transfer of Property Act 18. These are legal things. I don't want to get too much into it, but only point I'm trying to make here is that we should not be signing a lease agreement. Most agreements in the malls are leave on license. The basic difference between leave on license and lease is that lease, you give a possession to the lessor. That means he's got certain rights which they shouldn't be having in case they're part of a mall, because they don't give possession. You only give temporary access. That means you can only give a leave on license to the licensee. That's the main difference. But once you have a lease, then you have a serious issue, because they have a lot of rights which they shouldn't be having in case of they are doing the business in a mall, where it is their rights are limited to only the license providers only. What are the four basic components of the agreement? When you start talking to any retailer, you start talking the basic commercials. Then you have a right of licensor, because you own the premise, you have a right of licensor. Then you have rights of licensee, what license rights they have in the signing agreement with you. And most important, that obligation post termination and expiry. The agreement talks about termination right to a licensor and the licensee both. So what happens after the agreement is expired or it's terminated? What are the obligations from both the parties? So these are the basic four parameters when we talk about any agreement. Let's get into this one by one. Understand the implication of each of them. Term and lock-in period. So when you start talking about beside the rates, you start talking about the term and the lock-in period. Term may be term as agreed between both the parties. Generally, it is 3 years, 5 years, 9 years. In some cases, it can also go to 12 years where you have a very large anchor like a hypermarket or a theater. But generally, we prefer keeping to 9 years, because after 9 years, most of the state becomes like a lease agreement. And maybe we go up to 9 years, 11 months, but always below 10 years. Some cases, I say it is given to us because you don't really have much of a choice, because some anchor, where the fit-out cost is very high, they want this to be at least 12 years. But our recommendation generally remains 9 years. And most of the cases, if it is an anchor, smaller stores, keep it to 5 years only. Anything more than 5 years can be challenging for you in terms when you want to change someone, somebody is not doing well, you're getting a fresh brand to the mall. It's very important to have a lock-in period for the licensor. Again, very tough one with the licensee. Many licensees, they don't want to have a lock-in period, but very important for licensor to have a lock-in period, because most of the agreements in the mall, we do not have a right to terminate or right of exit to the licensee unless they breach. The meaning of this is that you will not be able to increase the rate even the market corrects. Let's say, for example, you sign an agreement of 100 rupees. Within 3 years, it goes to 150 rupees, but you cannot increase the rate because you cannot ask him to go. That means it's very important to have a lock-in from their side also. So we say 60% of the tenure should be a lock-in period. Of course, it could vary from brand to brand, but recommendation on remains at least 60% of the terms. If you're doing a 9 years agreement, we recommend have 5 years as lock-in. If you're doing 5 years agreement, have it 3 years of lock-in. If it is a 3 years agreement, you should have at least 2 years of lock-in. I say rationale is very simple. If you do not have a lock-in, you are locked in for the entire period. So you must have some lock-in from the licensing side as well. Chargeable area. What do you charge? How do you define a chargeable area? It's basically what is the common area of the premise. You take the total area and then you add this to license area. Then you do a charge, the loading. We call this basically a loading. It varies from mall to mall. Some malls have 100% loading for the vanilla store. Some have 67%, some have 50%. It again varies from mall to mall depending on how much of common area they have. Typically, an anchor can have a lower loading, anywhere between 25% to 50% or 60%. And vanilla generally has 65% to 100% again depending from mall to mall. And the licensee pays on the chargeable area. Not only the license fee, but also a cap. Many malls have something like a minimum guarantee and the revenue share. Why need a minimum guarantee? Because we do not have minimum guarantee, because the licensee may lose interest in case the brand is not doing that particular more. If he knows that there is no downside, he will not even take much interest. Number two, you do not control their operations. If their product is not good, the interior is not good, the experience is not good, they don't have good staff, naturally they don't have good sales. And if I'm only giving you minimum revenue share, then you have a problem here, because it's not in your control. As a licensor, only your responsibility to get people to the mall. It's up to the brand also to pull people to their own stores. It's very important to have minimum guarantee, and barring few brands, most of the brands, they do agree to minimum guarantee. It's up to you. How do you basically negotiate your commercial? My recommendation, you must have minimum guarantee, which could vary between 70 to 80% of your expected rent. So let's say expecting a rent of 100 rupees, and then you expect at least 80 rupees to be minimum guarantee, and forecast could be 100 rupees depending on revenue share what you can generate. So there's also from both the sides, you also have to perform and they also have to perform. Municipal tax is one again very important component of the agreement. Most of the retailers, again, they do not want to pay property tax because thinking that it's an expense for the property. But you know what is the drawback here? What happens in case we don't charge municipal tax to the retailer? The many commercial agreements are signed with a lower rental, and in cases I've heard that sometimes the property tax is higher than the rental itself. So you end up paying to retain a licensee. It's very important to have licensee sharing a property tax burden. I mean, formula could be different. You can have a formula of you pay the current property tax, and increment can be shared between both the parties. You can have current property tax payable by you, rest can be paid by the licensee. You can have various formula, but you should never agree on property tax entirely being borne by the licensor. For us, is very clear. In case the property tax becomes too high, and sometimes it can cross the license fee, then you have a problem. Number two, you don't have a control over the property tax, because that's the place of the government, a local municipal corporation. You can't control it. So something you can't control, why should you pay? That's the argument in case somebody talks about the property tax. Why should you pay property tax? And property tax is basically because somebody is occupying and doing the business on that premises, property tax goes up. Then you have CAM charges. I think all of you know what are the CAM charges, basically common area maintenance charges. Many brands again would like this to be fixed. Recommendation, no, you should never have this fixed, because a lot of things are not in your control. It's basically reimbursement of cost. So actual cost to run the operations, you basically recover from the licensing. Some malls have a surcharge on that. I mean, they're free to do that in case the licensee is willing to pay for it. But you must recover the actual CAM charges to run the entire mall, because as I said, it covers basically your maintenance, electricity, and the manpower cost. Again, these are not in your control. You're not a utility firm, so that electricity charge is not in your control. If the prices go up, somebody has to pay for it. Manpower, again, the salary is not in your control, because mostly it is governed by the minimum wages and the government policies. Nothing you can do about it. Then you have chiller charges, which is basically provide AC to the licensed premises. Again, has to be flexible. It can't remain fixed, because it goes every year, goes up every year. Electricity charges, which is basically a meter fixed to your licensed premises, collected on actual. Again, some malls have a surcharge on that. If somebody is willing to pay for it, why not? Otherwise, the actual charges must be reimbursed. Same with the water charges, at least for the F&B, if not too much for the retail area, but at least for the F&B. Water charges must be collected on actual. That means you must have a meter for all the premises where you're given a water connection. If you do not collect this from the concerned retailers, why should you ask somebody else to pay for it? So you must have water meter for each of those units where there's a water connection. The deposit, again, a bone of contention with a lot of retailers. They say, why should I pay more than 3 months or 4 months? Again, it varies from company to company, but anywhere between 6 to 9 months is a good deposit to have, because in case somebody wants to default, again, the licensing defaults, you must have some money in your kitty so that you can recover the cost of being there. And number two is always interest free. We do not even write refundable deposit, because if there is something they have not paid, we must have flexibility to collect those money from the deposit before paying it, refunding the balance. GST is always paid by the licensee on actuals. They may not get input credit, but that's not of our concern, because we are concerned because GST is not in our hand. We collect on behalf of the licensee and pay to the government. Due date for the payment, generally it is by 7th of every month in advance. But again, it could be flexible. Some brands say make it 10, make it 15. It's flexible, but you must make an attempt to have it at least before the 15th of the month. at least in the agreement. You may give some leeway in case somebody doesn't pay on time, but as far as due date is concerned, it must remain fixed, remains in the agreement. Fit out period, again, varies from store to store, the size of the stores. It can be anywhere between 30 days, 45 days, 3 months, 4 months. But you must have a limited fit out period. Because if you do not have, you're basically paying for their inefficiency. So fit out fixed period, it must be fixed. Fit out period must be fixed, which vary as if it is 500 square feet, maybe 30 days, if it is 1000 square feet, maybe 45 days. Is anchored maybe 3 months or 4 months. So if you do not do it, what happens? You are basically telling them to be inefficient. And number two, if they have no pressure to perform, they will not complete the fit out on time. It's very important to have a limited fit out period without any extension. It's also very important for them to complete the fit out on time, because you're not only interested in collecting money from the retailer. It's also very important for them to start the operation on a particular date. If you do not do it, what happens? You may have a mall that the fit out is going on, and you're getting rent, but that's not the only thing what you are in a business for. You're supposed to have the stores getting operational on time, so it gives you a better look to the mall. I mean, I've seen some of the malls where the particular company has taken more than 10 stores and they've not started operating. Just they're saying you're interested in rent, I'm paying you rent. But imagine out of 30 stores in the ground floor, 10 stores are shut because they say, no, I'm doing a fit out. Not completed, you pay your rent. So what happens in case the fit out doesn't get completed? You must have a right to terminate after giving a grace period. Some malls also give an incentive to complete the fit out before the fit out completion date. So maybe you don't charge them rent at all. If let's say you give them 45 days to complete it, they complete in 30 days. Your interest is that he must start your operation early. So you say 15 days, I may not charge you. You just pay me CAM, don't charge, pay me license fee. So that's an incentive for the retailer to complete the fit out before time. So that's in your interest because you're getting the store operational. And I say if you do not complete the fit out on time, they can be given a grace period, which can be reasonable, anywhere between 15 days or 30 days, depending on the size of the store. Anything more than that, you should never agree to it because it's an endless process. You must have a right to terminate. I'm not saying to terminate, but you must have a right to terminate because you know that what is the intent of the retailer. What are the rights of a licensor? Once you sign an agreement, when you sign an agreement, what are the basic parameters? You are here to give them a place to conduct their business. So they have a certain right, and as a licensor, you have certain obligations also. Besides having a right, you also have certain obligations. You need to ensure that the mall is run well, they have footfall, you do market event, keep the place clean. These are basically your obligations. Because operation maintenance control by license, you have to make sure it is all clean. You must have all the rules and regulations to be observed by all licenses in the mall. So it's very important to have the basic rules and regulations because if you do not have rules and regulations, and you have 200 retailers operating from a common premise, you can get into trouble. I'll give a very simple example. If a store is playing music which is very loud, which can disturb to the next door neighbor, it will be detrimental to the mall interest. If you do not capture this in the agreement or in the mall rules, you have no remedies. Somebody is not well groomed in the store. Somebody is not putting the lights on in the store, keeping the store closed, throwing garbage not in designated place. All these are problems. They don't open the store on time. So you must have license. You must have uniform rules for all the licenses so that they follow them. And you must have a right to take action in case they do not follow, which eventually should lead to termination because in case somebody does not listen to you all the time, you give them one notice, second notice, third notice, fourth notice, still there's no corrective measures taken. You don't have a choice but to look at a termination. It's very important to have very well drafted mall rules, which must be circulated. I also must have a right to update this from time to time because the mall working changes every few years. It could be the timing, could be the cleanliness, could be the ingress, egress, could be anything. So you must have a right to change those rules and update this from time to time. It's simple. A lot of brands, they say that you cannot have a kiosk in the common area. You should try not to accept this condition because again, you do this for their benefit. It's not just about for you or revenue. It's also about conducting events, promotions. A lot of these kiosks, I don't think the rental and the revenue is the main consideration. It's also about how to keep them more dynamic and more aggressive. So sometimes you have events, sometimes you have promotion, sometimes you do a pop-up stores in the common area. It's very important to keep the control with rather than giving a control to licenses as much as possible. I'm putting this as much as possible because there are some international luxury brands, they don't allow you to do that. But as much as possible, try to keep the control to yourself. Since you are locked in for the entire term and right to termination only on the licensee's default, so you must have a right to send a notice if there is default by licensing on the payment. What business are we in? You're a business basically collecting rent. That's the main business. If you do not get your rent on time, why are you conducting a business? It's very important to have this right to send a default notice in case the payment doesn't come on time. You may or may not exercise that right, but you must have that right in the agreement. And in case there is default, 2 default, 3 defaults, you must have a right to terminate. If you don't do it, they'll continuously default in making payment to you. As a deterrent, you have interest component, but I don't think most of malls they have their interest in collecting interest. Our main intent is to collect our rent on time, because a lot of malls have this discounting. They have to pay back money to the bank or have taken a debt. So it's very important to have this right to terminate if there's a default and continuous default. Licensee claiming any right over a bare license. Please understand, in legal term, we say we only give a bare license to the licensee. He doesn't get any other rights. He has access to the premise, nothing more than that. Anything more that he wants to claim, you must have a right to terminate automatically. Another thing is very important, when you have a right to terminate. A lot of these rules are governed by the state government and local municipal corporation, which again you have no control. Suddenly the government decides to modify the rule and make a rule that anybody who is occupying a certain space or conducting business from a certain space can have a right to the property. They can pass a rule. So license agreement must have a clause that in case something like this happens to any government notification, you have a right to terminate a day before the legislation come into force. Very technical legal term, is very important to have that right. If you do not have this right, you may lose the right of your property itself. You must take a right from all the licensee to mortgage, sell, raise loan, assign your rights. You must have all these rights, because end of the day you have very large property and you can raise money on that property. You can assign your rights to somebody else as long as it does not harm the interest of the licensees. If the licensee has a similar right with the new assignee or when you mortgage or through the bank, I don't think they'll have a problem. It's very important to explain these terms to them, why we're asking for these rights. It's very important to remain indemnified for any lapse by the licensee, including IPR violation. Because licensee, you are not policing the licensee store in their operations. You don't have the manpower and resources to do that. You may not be able to know what they're selling from the store. Okay, you may have a control over it. You may say that yes, I can control in the agreement. But actually, can you control 100 stores from the same store? It's not possible for you to do that. So you must ask for an indemnification from the licensee, because what they're doing, they are not in total control. See, somebody takes you to the court and sues you for any kind of money. How do you protect yourself? IPR violation. Maybe they have lost the right to sell a particular brand. Maybe you're not aware of this, and they're still selling it. How do you protect your right? So it's very important to get indemnification from all of these, because as I say, you cannot control the entire licensee activity in the operation. So you must protect yourself. The idea is that you protect yourself from all these kind of defects which can happen over a period of time, because if you understand, they're very long-term agreements and you don't have the resources to keep checking everything again and again on a regular interval. So the best course of action is that how do you protect your rights? So through these agreements, you protect your rights. As the idea is that licensor must remain indemnified for any of these violations, any of these issues that can crop up later, which you have no control. What are licensees' rights? When they sign an agreement, licensee, what exactly they're supposed to do? We sign an agreement to a licensee to conduct a particular kind of business, and we facilitate that. So if we allow them to sell a particular product, a particular brand, they only can sell that. They're not allowed to sell anything else which is not permitted by the mall. In many cases, you must have seen or must have noticed that you allow a particular brand or store to sell a particular product, and when you go out to sometimes they're selling something else too. You must protect your interest. One is IPR violation. Number two, they're not allowed to do that. You have got a licensee to sell a particular brand. He has no right to sell some other brand. You have got a license to sell a particular product or services. He cannot do something else, because if he's doing something else, you're basically jeopardizing somebody else's interest. For example, you have one brand selling a particular garment. There's another guy selling who's not an MBA or an EB. He also selling the same garment. That means so you're basically harming somebody else's interest. You can also go to F&B. In F&B, same thing can happen. We generally we should control the menu. For example, you have got a particular outlet you have signed to sell a particular cuisine. Suddenly you realize he's selling something else than a particular cuisine because he thinks that's not selling, he wants to sell something else. You must have a right to govern the menu. Because if you do not do it, you're harming somebody else's interest. A simple example, somebody is selling Chinese is not doing well, he starts selling Indian food. If he starts selling Indian food, what happens to the neighbor next door who's selling Indian food? His interest is getting harmed. It's very important to basically restrict the menu what they're selling. I mean, they have a right to add more, but with prior approval, with your consent. Licensee, I say, only has access to the property, he has no possession. They only have a right to use the licensed premises. That means they only have duplicate key. I mean, it has no material meaning, but generally we say he only gets a duplicate key, not the original key, because he doesn't have a possession. Possession remains the licensor all the time. They have no right to continue beyond the term. So many malls, what they do to make it so difficult for the licensee that after the agreement expires or gets terminated, you pay me 3 times the rent. So that you make it so difficult that he leaves after the agreement expires, unless you permit them to operate even beyond the expiry by signing an additional agreement or extension. Please keep in mind the practical difficulty. Why do we say that? You have signed the same store with some other brand. Let's say, for example, a license expiring 31st of July, and a new brand comes on board from 15th August to start the fit out. But the previous license is not left on some pretext or the other. What happens to the incoming license? He has a problem. He has mobilized resources, he's got his manpower, he's got his materials, but he can't start the fit out. So it's all connected to each other. So when you're talking to a retailer, you must make them understand why do we say that you must leave when it is agreement expires, unless you have previous understanding of an extension. So these are very logical clauses, which must be explained to the incoming retailer or to the licensees. I don't think you need a legal person to explain this. Very commercial point of view. You also have a right. Many malls have an agreement which says that once the agreement expires, you do not vacate. Of course, there's nothing to vacate because it's not the possession. Licensor has a right to remove all the goods and keeping the good on for a particular period. I mean, you can forcibly take this. I'm not saying legal point of view, but you should have a right to remove all the goods and put in a good on for a certain period of time, and then you have a right to dispose if they don't claim this. Because if you don't do it, you have a problem. Because you already signed an agreement with somebody else who's supposed to come and start a fit out, but he cannot because previous license is not left. So these are very logical things. Restrictive rights and certain obligations. Business is stated to permitted businesses only. So he's been allowed to conduct a certain business. He can only conduct that business, nothing else. Nothing less and nothing more. When you say nothing less, that means if he's supposed to sell a particular product, he must sell that particular product in a right quantity. That means he should not have a store which has less merchandise than he's supposed to have. Because if he does that, what happens? He's not selling. He's not saying that he may not be able to pay UMG or a revenue share. It's very important to get into audit and monitor this. And you must have this right in the agreement itself. If you do not do it, what happens? A particular store is compromising in his own standard, which eventually will harm the interest of the mall as well. Very important to have regular audit for the stores, and you must have a right to conduct the audit in the stores, which has to be part of the agreement. The business hour must be controlled in the licensed premises. Again, has to be part of the agreement. When you say the mall must open at 10, the store must open at 10. He must close at 10 p.m., he must close at 10 p.m. Nothing more or nothing less. So if you don't do it, you get into a bigger problem. A customer who's come to the mall and expects the store to be open at 10 in the morning, and he comes at 10:30 and he says the store is not open, then it is basically compromising on the mall interest and their reputation as well. It's very important to control the business hours and make sure everybody adheres to that guidelines. It's very important to ensure that stores are open all days. All these are part of the agreement, and what I'm saying is all part of the agreement. You have to ensure all this happens. And you have to, when you're negotiating these clauses with the retailer, you have to make them understand as a normal consumer. I'm sure when you talk to them as a normal consumer, he'll understand. Why we say it has to open all the days? Because maybe a customer, a visitor comes to a mall to a particular store. He's very clear in his mind that he's seen an ad on a website, this particular store is there in the mall, so I'm coming here for shopping here. And he comes to the mall and he sees the shop is closed. He gets disappointed. See, losing trust on the mall. It's very important to ensure that all the stores are open all the time, as per the mall working hours. If they are closing for some purpose or other, they must take a prior approval. That also should not be given in unlimited number of days. It should be a limited number of days. Because if you don't do it, you're disappointing a customer, which you do not want to do. The fit-out guidelines says very clearly that you cannot do structural alteration in the store. I mean, generally it's a strict no-no. But in case something is required for them to do it, they must take licensor consent. That means it tells you that whatever fit out they have done in the store, they have taken you prior approval before doing the fit out. That means you have a right to say no when they're doing the fit out in the mall, in the store. You can deny them because you have fit out guideline. You're looking at overall mall look and feel. You can't allow them to do something which is going to harm the interest of the mall itself. For example, the signages. Most of the malls have particular size for the signages. They just can't have larger or smaller. They can't make structure change because they do not know the structure at all. It may be a load-bearing beam or a column. They can't make changes there. But they will not know what happens beyond their store. But you know exactly about the mall, what is what. Is this column or beam taking load? Is that brick wall taking load of something? So no structure changes at all. In case they make it, you must have a right to terminate. Licensee has a right to check, which we call this due diligence. They must have the right to check the property documents. I'm not saying they need to share it, but if they have, they must be fully satisfied that this mall which has been built or any shopping company which has been built is as per the regular approval and the rules of the local body. If there's any litigation with the property, it must be declared with a very clear understanding. If it affects the licensee's rights, they have a right to exit without paying any compensation. At the end of the day, they have come here to do their business, conduct their business. They're paying rent for that. So if something that has happened which is harming their interest, they must have a right to exit. There is none of their fault. If there is a case against your property and authorities come and shut your mall, which is none of their fault, I think it's fair that they ask for an exit without paying any compensation. They have a right to ensure that their access to the premise of the licensed premise is never compromised. Now legally you can work the way you want to, but I think they have a right that their access should never be closed. You can't have a scaffolding outside the store and doing some kind of construction. That's not correct. You have to ensure that this doesn't happen. In case something like this happens, they must have a right to exit. You must provide them your basic utilities, which is electricity and water. You must ensure that the maintenance of the entire mall is done to high standard because they're paying for it. They're paying the camp charges. Number two, some of the brands they demand highest quality. It's very important to make sure that your premises are extremely clean, secure, hygienic, and safe for the customers. After lock-in, they have a right to terminate by giving a notice period. And that's in all the agreement. Let's say somebody's got 3 years of lock-in period and got 6 months notice. After 3 years of lock-in, give a notice and exit. Some of the agreements, they also have this provision to leave even during the lock-in period by paying compensation. Could be for the unexpired tenure, could be paying a few months rental and exit. Some of the brands, maybe they have lost the license, so they can pay compensation on exit. All these are basically subject to negotiation, but all these things do happen where, the intent is not to exit, but the brand is exiting because maybe they've lost the license or the brand itself exited the country. If it is logical, and you can have a compromise formula. You may or may not capture this in the agreement, but you must have this understanding. Some of the brands, they insist that it must be part of the agreement in case they've lost the license for not their fault. You have the government regulations, some sanctions, they have been asked to go. So you can work out a situation, a compromise formula that you pay 50% of your lock-in period and you leave. So these things do arise. What happens post termination and expiry? First of all, you have to make sure the licensed premises comes to your company. They are supposed to remove all these employees and goods. Has to be part of the agreement. As I said earlier, licensor has a right to remove all the goods and restrict entries. You must have a right to take the premises either in bare shell. You must try this either in bare shell or retaining the fit out which is fixed to the wall and the floor and the ceiling. Now, why do you do that? We do that because if somebody is exiting the premise, he may not be very careful in breaking them because anyway he's exiting. He may damage your floor, he may damage your ceiling. So generally, most of malls, what they do is that you leave something that is fixed to the wall or to the floor or to the ceiling. You try to retain both the rights. That means they do bare shell under your guidance. That means they don't damage anything. Or in case you want to retain the store as it is, so that you can do a pop-up or you can use that fixture for somebody else, you can tell them to keep this as it is. You must retain one of these two rights, and you have both the rights. You must hand over the duplicate key of the store. You must have a right to adjust anything which is outstanding from the security deposit. It could be your pending bills, could be invoices, could be some property tax which is outstanding. could be your TDS, could be your maintenance charges, could be your electricity bills, could be any damage when there is leaving the store. So generally, as a rule, what the licensor does is that deposit will be refunded only after you have vacated the space and you have signed the expiry agreement. That means the relationship ends with the signing of a document. Some brands, they say, no, why should I block so much money? So why don't you pay me a part of it, and you keep one part of it, which can be adjusted against any of your claims and any of outstanding. Refund part of this deposit to me. So again, that's a commercial call to be taken, but you should never refund entire money because you don't know what can happen in future. There are many other subjects which is important to understand, which is not part of this, but I must take those points also when you're signing an agreement. Clauses comes like insurance. Whose responsibility is to take insurance? It's very clear, the insurance which is pertaining to the property for the common area and the license and the entire mall is taken by the licensor. But the licensed premises insurance must be taken by the licensors, which will cover their goods, their fixtures, their fit outs, and also the third party claim. When I say third party claim, what happens if there's an accident that happens in the store? As long as the person is in the common area, they're my customer. When it goes to licensed premises, no more my customer, is your customer. Something happens to that customer, who pays for it if there's a third party claim? So they must take that insurance. Again, this is very tricky. A lot of retailers they try not to accept this liability. But in reality, it is their liability, because the moment a person leaves the common area and goes to a particular store, he's no more my customer. He's your customer after that. Another thing very important to capture in the agreement is about staff entry and exit, which is generally covered the part of the rule anyway, part of your mall rules anyway. But some of them also must be captured in the agreement, which can lead to your sending default notices. Another important thing is to regulate the employees when this it may sound a little funny, but it's very important to control who they hire. Because as a mall, you are in a better position to know if they're hiring an employee who may have done some fraud or something mischief in the mall in some of the store. They may not know about it, but you are aware. See, again, it is not possible for you to govern so many things, but you must have a right. If a mall has, let's say, 3,500-4,000 employees, possibly it's not, you can't possibly screen all the employees, but you must have a right. Why you should have a right? Because the same employee may have done some fraud or theft or some mischief in some other store, which the other store may not know, but you know about. It is very important to have that right. Then you talk about employees' discipline. It could be part of the mall rules. It's very important to have designated spaces for smoking or eating in a canteen. You can't have people eating anywhere. This can only be regulated in case part of your rules. If you do not have, you can't challenge them. End of the day, you're running a place which has got multiple number of people, multiple number of stores. You're a facilitator. It's your obligation. It's your duty to make sure that there's some kind of discipline in the mall. This can only happen if you have certain rights. Or you can take certain actions. If you do not have those rights, nothing you can do about it. And just a retail audit is also very, very important. You need to ensure that the stores are functioning the way they're supposed to function. You must have a right to audit. You also must have a right to audit the revenues to be part of the agreement. Because in case you have revenue share and you just take what they tell you, you may lose out. You don't know, are they capturing and all the revenues in the agreement in their point of sale or no. So you must have a right to audit the revenues, and they could be a benchmark for you to understand. Another sticky point becomes about your logos for your marketing and promotions. As a mall operator, you're expected to promote the mall. How are you going to promote the mall unless you have a right to advertise their brand as well? It is not possible for you to go to each and every retailer to get their consent to advertise. Generally, you see most of malls, when they advertise, they have all the logos as a panel, some in the ad. Imagine you have to go to 100 stores, 100 brands to get their consent. It's not possible, because you go to the store, you say, talk to a brand. You go to brand, you talk to the business head. You go to business and talk to the brand. Imagine you have to talk to 100 people to get a consent from them to put an ad. It's very important to get their consent in advance. That means in agreement itself. That means they must give you their logos to advertise. They're free to tell you that when you're advertising, please make sure my logo is next to this. They're the like-minded brands. They're okay to demand for all this. But you should never lose your right in taking that permission right at the time of agreement itself. Like I said, it's humanly impossible to go to each and every brand every time you want to advertise. These are actually very, very important. Many brands, when they sign an agreement with you, especially the anchors, they want a permanent holding. I mean, they're very quick in asking for it. After a few years, they realize they don't need it anymore. But you only sign an agreement with them. The agreement must state in case you've taken a permanent holding, you have to continue till the end of your tenure. Again, I have seen this happening. Somebody's taken a holding, but they don't use this anymore. Or they stop paying your rental, they stop paying electricity bill. Again, you must have a right. So it's very important to understand what you write as a licensor without really compromising on the licensee's interest. So you need to get the fundamentals right. Licenses, you have to conduct your business. You have to facilitate the entire business, ensuring that your rights are never compromised as a licensor. If the understanding is correct between both the parties, I don't think it's going to be any problem. You should never leave any ambiguity in the agreement. Sometimes people say use the like mutual understanding. I mean, mutually you can agree to disagree. Then what happens to the agreement? The agreement must be very, very clear. This is your right, this is my right. You fulfill your obligation, your rights, I have fulfilled mine. Then there's a clause called force majeure. I think all of you who've been in the business for the past 3-4 years will understand what is the force majeure. Something that is not in your control. Why would you waive off the rental as an obligation? You may choose to do so later. That's a different thing. That's a commercial transaction. But as far as your rights are concerned, no, it's a strict no. Force majeure means only when the property gets destroyed. You cannot enter the property and you can't conduct a business because the property is destroyed and license is not able to rebuild the premise in the next few months. Now that can be defined in 3 months, 6 months. If it is not done, they have a right to exit. They have a right to terminate. But something like a lockdown or a strike or a pandemic, you should never have a right. You should never give a right for them to not to pay rent or canopy. Finally, the business what you are in is collecting rent, and they have not vacated the space. They still have the space. You are charging for the space, so they can't refuse to make payment to you. You're still paying your rental. You're still paying your property taxes. You're still paying your fixed charges. Number two, you can't rent out to anybody else because you have the space with you. Very clear logic. As long as the space is with you, unless you vacate, that will never happen. They have to fulfill the obligation as per the agreement, where it is. I mean, they're after lock and you want to exit, they're free to give notice and exit. The force majeure also you have to explain to your licensee that why you still have to pay rent. That's your obligation to pay rental because place is still with you. You may choose to waive off. You may choose to give them a discount. May choose to structure a deal, but not as a right, as a negotiation. If you don't do it, once you give them a right, there's no end to it, as we have seen in the past. Number two, when you're giving them a waiver or any kind of discount, it must be in a phased manner. It can never be unlimited. Those are negotiations, of course, that is post-agreement signing, but it can never be that I'll give you 1 year. Any of these waiver discounts should not be more than a fixed period, which maybe could be 2 months or 3 months. So you'll review after 3 months. Take a moment to give them a longer period, they lose interest. This is because they have no downside, but you have a huge downside. Now, sticky subject comes about the parking for the employees. A lot of stores, they want, you must have few parking space for the employees and the managers. I think they also must be restricted. Can't be unlimited because at the end of the day, you have built the mall for the customers, not for the employees. Maybe the anchor store can be given a 1 or 2 car parking, a few bike parking. But generally, you should avoid this because once you do this, you're basically compromising on the customer's interest. They're being deprived because they don't have parking spaces. And anything that is free can get misused. So I always advocate that don't give anything free to anybody. You must have charges for it. Maybe a nominal charge. Because I've seen many stores, many backroom stores where things are just done because they're not paying for it. They don't value it. F&B licenses are very important that, you must have a right again to check the quality, tell them to take corrective measures. You also have a right to check the kitchen, check the food quality. You may or may not do it, but you must have a right. There are many brands, what they do, they say in the agreement, they write product and accessories. I firmly believe that you must write the percentage. Let's say somebody say, I want to sell footwear and accessories. What percentage? It shouldn't be other way around that they're selling less of footwear, more of accessories. You have got them into the mall to sell footwear. Accessory should remain accessories only, shouldn't become a main product. So if the shelf can take 100 products, 80 must be the main product, 20 could be accessories. You must also put a number to it. And that also should be part of the agreement because you can challenge them in case they don't adhere to those rules and regulations. So these are basically all commercial negotiation. It's less of a legal thing, more of a commercial negotiation. I don't want to get into legal clauses, but when you're talking to a licensee, if you're aware of all these things, that what you're saying, what you're writing, has a rationale behind it. You're not saying top of the hat, you're saying something very, very rational. Let them counter it. And believe me, the way most agreements are drafted by the licensors, they're very logical. You also must understand that any commercial negotiation, when you start with the brand, doesn't have to close with signing an agreement. may or may not happen. When you do 100 negotiations, no, all 100 negotiations will not materialize. You have to keep that in mind, but it has to be brought to logical end. Negotiation with is commercial or legal both. You must know is a disconnect when negotiating the agreement. It can start from your commercial. It could be a lock-in, could be a tenure, could be your fit-out period, could be any of these. But you need to be firm when you're discussing any negotiation and discussing any company. You have to be very, very firm about it. Number two, most of the time we assume that they have all the information. They may or may not have. Now there are tools available for you when you're negotiating any kind of deal with any brand. There are many tools what you have which you can use them. We're talking about a commercial transaction, looking at the legal clauses. There are many agreements which you can download from the system. So you know what rent they are paying, what CAM they are paying, what is the agreement they have signed. You have those tools. You may or may not really mention to the licensee, but you should know that you have the weapons to really counter them. Jalatan, we assume that, he may or may not sign, he may not pay our rent. Why do you assume things? Same thing with the licensee, with the legal clauses also. End of the day, you're very clear that we have a certain right, we must exercise our right. This is my property, I must protect my property. You're here to conduct business, I allow you to conduct business. But at the same time, we need to be very clear, we need to be very fair to our licensees. We don't want to be unfair. They must understand, they must realize, and they must have the faith in you. Because I see you're a licensor, and sometimes you have greater control than what they have. They must know that we have their interests also in mind. Because we sitting in the mall, we know about the brands and the stores more than somebody sitting in Delhi, Bombay, or somewhere else. We get right there on the spot. They must have that faith in you. So when you talk to them, they understand that we are doing for their benefit, not for our benefit. Some of the terms like escalations, insurance, they all try hard, but there's some standard benchmark. I think you should try to stick to it. Auto renewal is again something which generally I don't advocate. It should be after term expires to renegotiate once again. You may give them the benefit of similar kind of commercial, but as for the right of property is concerned, should never get compromised. If there is a proper understanding between both licensor and licensee, I don't think you're going to have any kind of issues. You need to basically somehow have that trust between both the parties. Once you have that, when you have that faith, I don't think you have any problems. The agreement will just happen. You must have seen that many retailers don't even read the agreement, they just sign the agreement. There are some retailers, they negotiate very hard. It's very important, as I said, you have to hold your nerves. It may take longer, but you're very serious to get this brand, and the brand is very serious to be part of you, it will happen. Because there's a compromise from both the parties. It has to make sense to them, it has to make sense to you. But most of these basic clauses must be captured in the agreement. It can't be mutual understanding. We'll see it later. You get into litigation, and nobody wants litigation. You don't want a store to remain closed because of the court order. So why you should not go to the court? If you have an agreement which is very clear, you know exactly, there's no ambiguity at all. This is your right. You have not fulfilled the obligation. You have not paid your dues. I gave you one notice, two notice, third notice, you're supposed to exit. We have a right to terminate. They will not get into litigation. They all have to be part of the contract. We can't leave things on understanding. We'll see it later when it comes, we'll see. Doesn't happen. They all need to be captured in the agreement. And I can see there are a lot of questions there on my box.
Okay, Mukesh, we have got a few questions. So let's start our question answer session.
Yeah.
The gentleman has not mentioned his name. His question is, how do you convince the brands for non-operational charges?
What charges earn?
Non-operational charges. How do you convince the brands for non-operational charges?
I don't really know what exactly is saying non-operational charges. If it is a CAM, I understand the common area maintenance charges, that is operational charge. There can't be non-CAM charges. These are anything to operate the mall. These are operational charges. If you're marketing your property, your premise, it's a marketing and promotion charge that they have to pay for. Because what is being done in the mall, they're all operational charges. They cannot be called non-operational charges. I say you need to be very fair. You need to define your charges. Some charges which is related to the mall only, then you can't charge that to retailer. For example, the insurance of the property. You need to be fair. Insurance is basically related to the mall premises. Common area, which is not really possible. We can't pass that cost to the retailer. See, as long as you're honest. And today also, most of the malls, they keep it very, very open, very transparent. You have a right to come and check our books. For any CAMEX can come and check our books. I say you need to be very fair. That's why you need to have that trust and faith in each other that this mall will not do anything which is unethical. There are some charges which are not supposed to be collected from the mall. Like, for example, you're doing something in the store, building a partition wall. Now that's your expense. It can't be a common expense at all, because that you're doing this to collect your revenues. Parking is basically a revenue generating department. You can't charge the parking expenses to retailer. Maybe a part of it, maybe 10-15%, but not the entire parking expenses, because that's a revenue stream. Sometimes most of the malls, they also have expense for legal. Now you are using a legal resource to sign an agreement. That's not called common area maintenance charges. So this format can change very here and there, but I think overall, as long as something which is part of running the mall, operational expenses, and part of running the common area, to be collected from the licenses as a common area maintenance charges.
Okay. Another question is, how do you impose the minimum sales guarantee commitment on the license?
That's called performance clause. It's called performance clause.
Okay.
So they must perform to minimum level. I mean, it's very tricky, because they may ask you the same thing. Will you commit a minimum footfall to the mall?
Yeah.
You possibly can't. So how do you protect it? You say you must give minimum guarantee. So if you do that, even if there's no minimum sales, you're okay, you're covered. But minimum sale performance guarantee, if your mall is doing extremely well, I don't think you really have a problem, because they'll be happy to give you minimum commitment, because they know they will do well. They're very confident to be in part of your mall, because they know if they do not do that minimum sale, they will not be able to afford to pay the rental. So they'll have no problems. So any performing mall doesn't have this kind of challenges.
Okay. Center manager Lido Group. His question is, does the rights of the licensee change in a lease agreement?
Yeah, it does. Because he becomes a lessee. If he's a lessee, then he can't. If you go back to the first slide, it says very clearly, let me take him to the first slide. How it is defined: a lease of immovable property is a transfer of a right. That means you transfer your right to such a property. So right is not with you anymore. He's got the possession, so he's got a right to the property. In the license, he doesn't get a right to the property. He only gets access to the property. Once you give a right to a property, he has many other rights. But in license, he doesn't get a right to the property. He only gets a right to access the property. They're two very different things altogether. That's why we recommend not to sign a lease agreement, sign a license agreement. You're not transferring your right to the licensee in a legal license agreement. But in case in the lease agreement, you're transferring your rights to the lessee. Then he gets a lot of other rights, which we want to avoid.
Well, a gentleman wants to know, could you let us know what is the importance of registering the agreement?
See, if you register the agreement, there's sanctity to it. You can file this in a court of law. It safeguards your interest as well as licensee's interest. That means you have a government department who's accepting your agreement between both the parties. So if you go to the court of law, this has been vetted by somebody who has the right to vet that agreement. So by paying stamp duty registration, doing a registration, you're keeping yourself safe. So in my view, you must, if it is provision to register the property, you must do that.
Mukesh, Priyanka from DB Mall is asking, marketing fund can be charged to the retailer?
Of course you can. You must, in fact, because you're marketing the mall for their benefit. You don't do marketing to market you, because if you see any marketing ad that comes in the paper, you must have all the logo of all the retail, the major ones that can pull people. So any marketing expense to the mall must be part of the camp, because at the end of the day, you're doing it for them, not for yourself. Whether you do a marketing, you go for an event, you do a marketing promotion in the mall, you're doing an ad, you're doing a social media ad, you're doing a print ad. They're all part of marketing to promote you and your brands and your other brands in the mall. Whether you're doing an event, you're doing a food festival, you're doing all this to bring in more people to the mall. So that basically indirectly benefits you as well.
Okay. Well, there is a question post COVID-19, the clause of force majeure, however you pronounce it, has come into play. What is best negotiation as a licensor?
I covered this in my when I was talking about this earlier also. Force majeure, I said, can only be when the property gets destroyed and you can't rebuild in a particular period of time. Anything else can be considered force majeure, but they still have to continue paying rent because they still have the space with them unless they vacate. So how do you handle this? When you're negotiating a clause, you say, okay, fine. If there's something like this, I give you a right. If it continues for next 3 or 6 months, you have a right to terminate. But you still have to pay me rental for that period. Because end of the day, place is still with you. Business I'm a rental business. As long as the space is with you, you have to pay me rental. We have no way said that you pay me rental to generate money. You're paying rental because you've taken license premises. That's the argument for this.
Okay. Nehat from Lulu India, her question is, it is important to get the duplicate keys at the time of handover after termination, as we already have one set of keys with legal for that store. I think she has not framed her question.
I understood the question. That basically a notional thing that we have, our relationship is ended. Collecting duplicate is basically a very notional thing. It is not that getting to the store, you already have the key to get into the stores. But once you take the duplicate key, then officially you're telling the retailer, our relationship for this premise is ended today. So that's why we say it's called signing of an expiry agreement, expiry deed between both the parties, that yes, we had an agreement with you, it is expired, we are signing that agreement, so you give me the key, give the key back to me. See, basically an official notional thing that you're giving the key to me. So there's no dispute tomorrow. You have handed over the key to me.
Okay. So, Mukesh, we had a very interesting session. I hope our viewers must have enjoyed it. It's a real learning. You have shared your insights and experience. So, we thank you for conducting this enlightening session. And with this, we conclude our.
I think there are a few more questions which I can take from here. Question about what do you suggest that should be the proper way to circulate, update mall avenue routes? First of all, it has to be part of an agreement. Make this as a schedule of an agreement, which is subject to change. Once it becomes part of the agreement with a very clear understanding that it is subject to change. Then you circulate this periodically to all the retailers, maybe once in a year, and also display some of the rules. If it is for retailer, it can go to one of the staff area or something. If it is for the customer, it can be displayed outside at all the entrances. But for retailer, must circulate once in a year, updated mall rules. So people, they must know there are malls, so they must abide by it.
So with this, I think
there's another one. Let me. There are some more questions. Let me answer that.
Yeah. How should the fit-out deposit amount be derived? Kamal Soni from Prozone into his asking.
Yeah.
How should the fit-out deposit amount be derived?
How should the fit-out deposit
amount be derived?
I'm not able to read this.
How should the fit-out deposit amount be derived?
It's a fit-out deposit.
Yeah.
I think we take a security deposit. Fit-out deposit basically to understand there's a damage to the property. When you're doing a fit-out, if there's a property that gets damaged, so you must have deposit from them. I mean, you could have something like per square foot kind of cost. Let's say charging a license fee 100 rupees per square foot. Maybe part of it can be taken as a fit-out deposit for any damages which can be recovered from. You have to have a formula. But as long as you have a deposit, I don't think this is very important. If you have a security deposit from them, if there's a damage, you can adjust this against the deposit. There's a long question here for somebody. Let me answer that.
Yeah. What is the best
How to enforce lock-in? Brookfields, Kamakshi is writing. Practically, how do you enforce lock-in? You have a deposit with you. There's an agreement in play which says there's a deposit, there's a lock-in. Somebody wants to exit. I mean, you have, let's say it is 6 months lock-in. You can't leave, nobody wants to leave like that. They have the fit out there. They have the deposit with you. They have the merchandise with you. Why would somebody leave, leaving all this behind?
Ganesh Manjarekar from Phoenix Mall.
And can you let me answer all the questions? There's another one. Deposit for utilities. Of course, it should take deposit for utilities because that's also in case somebody leaves in between, you must have some deposit for utilities. It has to be part of you must have deposit for utilities, water or maintenance, electricity charge, you must have some deposit. I mean, you can look at the average cost per month for water, electricity, you must have deposit. How to enforce menu with QSR at KFC, which is putting biryani right now. It's a tough part. So what I would suggest in this case is that in case any international brand, they want to have the flexibility to add more thing in the menu. Yes, you can give them flexibility, but you must put a condition that as long as it is being practiced in all your outlets. If they don't agree to all the outlets, at least your regional outlets. Say, for example, they introduce something in Mumbai. You say, can't be only in your store. It has to be in all the stores of the region. Why do you do this? Because they may have something which is basically only to promote the product. They may give it free to the customers. That means then you're not getting any revenue out of that. So if somebody say, yes, you want to add something in the menu, if it is national menu, I'm okay with it. Because selling nationally. If you're selling regionally also, I'm fine, but you just can't sell a product only in my store. Because you may trying to do this to promote your product as a sample. So if you're doing regionally or nationally, I'm okay with it. Mall gift card voucher possible to implement, is it worth it? I don't think so. I think this is a passe now. Mall gift card and voucher is not working very well because so much of online presence today. Why would somebody take a mall card and he restricts himself coming to just your mall? Because he's got various choices. I mean, this a lot of people have tried. I don't think it really worked very well unless you get them some kind of value out of this. If you have some other value to give, well and good. Otherwise, very difficult to get any value out of this. Differential revenue share for omni delivery sale. You should try to have the same revenue share from the entire sale, but in case somebody insists and they are pushing, maybe 10% lower than your actual revenue. This is the agreement. Advertising a promotion of the online store handle at the stores, case to case basis, but generally we should avoid this because you're not, why would you promote online sales when you already have offline channel there? You should avoid this.
Okay, then Kamal Soni Prozone into question is stock take by anchor.
Then there's another one here. How to convince a corporate to pay rent on super built up area? Generally, they don't agree. No, they must agree because the mall has two kinds of area. One is licensed premises, one is a common area. Who pays for the common area? I mean, somebody say, I'm not going to pay you on super built up area. All right, don't pay me. Then I'm going to charge you if my loading is 100%, I'm giving you a carpet rate of 100 rupees. I charge you 200 rupees. You don't want to put that in the agreement, I'm okay. You pay me on carpet, but double the rate. Super built up area is basically any area which is basically meant for the retailers, for the licenses. It is not for anything else. There's a common area to facilitate you. If somebody is coming to the mall, he's not just walked into the store, he comes to the lobby, to the ATM, to the escalators. Somebody has to pay for it. Who's the somebody? The licensee only. So they need to pay for this. They may say, don't put this in the agreement. It's a fine, you pay me double. It's a calculation.
Okay.
Yep.
The question is, stock take by anchor brands often goes into operational hours. And how can we stop this bad practice, or what should be the penalty here? Kamal Soni from Prozone is asking.
I think first of all, you should never allow this. Again, the same thing, put yourself in consumers' shoes. If you are a consumer, will you go to where the audit is going on? I think they get the big enough window. I mean, 9:30 the mall closes or 10 o'clock the mall closes, you're opening next only at 10, you have 12 hours. Do in phased manner. They need to find a way out how to do their inventories. But you should never allow them to work during the operational hours. It's up to you how much you put sense to them, and you can only put sense by being a consumer. If you're a consumer coming to walk into a store, so there's audit going on, will you like it? These are hygiene issues.
Okay, Mahen Rai is asking, sir, why the loading for QSR and kiosk is higher than retail stores?
QSR, the food court loading is generally higher because the common area of the food court, which is the seating area, somebody has to pay for it. Who's that somebody? Somebody who's doesn't have their own private premise for service. So if you've got 20,000 of common area and 5,000 of a carpet area for the QSRs, those 20,000 have to be loaded to those QSR only. Why would the retailer pay for the food court seating, which is only meant for the people who are coming to the food court? That's why loading higher. Number two, they also save money because they're not doing services. We pay for the mall pays for the AC, mall pays for the services. They only pay the rental for their cooks and maybe one or two service the cashiers. Rest all the expenses are basically paid by the mall. So that's why the loading is much higher.
Okay. What do you suggest the mall to do in cases where the retailers try to unite to protest the CAM escalations?
First of all, it should be part of the agreement. You can't make an association. And CAM escalation, as long as they know that there's a value to it and the method of working is very transparent, this will never arise. And if they're doing well, somebody objecting to CAM who's not doing well. Otherwise, CAM is never an issue, at least in past few years. It used to be an issue long back. Not anymore. If the mall is doing well, the business is doing well, retailers are doing, they will never object to this CAM escalations because this is logical. Every year you pay higher salary to your employees. Every year you pay higher charges for electricity. Why do you object to it?
That's the point. So, should we conclude today's session?
There's nothing else. I think
we'll keep getting questions, Mukesh. So
you can share my mail ID in case somebody wants
definitely,
to.
Yeah, we'll share our email ID with our viewers and shall be posting questions to you so that you may answer them. So with this, my dear viewers, we are ending today's session. And once again, I thank Mukesh for conducting such an interesting, enlightening and informative session.
Thank you. Thank you very much, and thank you everybody who's participated in this webinar. Thank you very much for having me.
Yeah.
Thank you.